I'm Richard Ruddy, and welcome to the Probate Nation. Healthier lifestyles and access to quality health care are allowing people to live longer. However, with age, not everyone stays as sharp as they were years ago. And typically, children are called upon to support aging parents with their decisions. Unfortunately, most folks have not signed important legal paperwork officially authorizing those children to act. So those children are not able to provide the financial and medical decision-making help that a parent might need. Instead, they have to head to court to obtain legal authorization to do so. Over the course of 2 shows, we will cover the legal procedure in Alexandria City to obtain that authority as a court-appointed guardian and conservator. Tonight, we are lucky to have 2 local attorneys with the expertise and experience obtaining this authority for their clients. They will be our guides as to the do's and don'ts in seeking this authority. And we'll hear about the typical issues that come up and the dangers to steer clear of if you decide to get on what we call the living probate train. Our first guest is an attorney with the Westreich Law in Alexandria. His practice focuses on estate planning, estate and trust administration, adult guardianships and conservatorships, and fiduciary and civil litigation. He represents the Alexandria Department of Community and Human Services in many guardianship and conservatorship matters. Our second guest is an attorney with the law firm of Christopher Mays, PLC, also located in the city of Alexandria. His practice focuses on estate planning and administration, guardianship and conservatorship, probate issues, Medicaid planning, as well as the preparation of premarital and marital agreements. He serves as a guardian ad litem for incapacitated adults and represents clients in involuntary hospital commitment hearings. He has been recognized as a top lawyer by Northern Virginia Magazine and Super Lawyers. Please welcome Alexandria attorneys Jonathan Westreich and Chris Mays. Gentlemen, welcome and thanks for being on the show today.
Thank you.
Happy to be here.
Now, Chris, let's just jump right into this. What are some of the more typical estate planning important medical decision-making documents that someone should execute?
So the big ones are going to be an advanced medical directive and medical power of attorney or a healthcare power of attorney. The healthcare power of attorney will allow somebody, designate somebody to make decisions for you. We have an advanced medical directive where we talk about certain types of healthcare, usually end-of-life care. And then there's other documents such as like a HIPAA release you'll see sometimes. And in addition, there's other documents that are not necessarily prepared by attorneys, but are prepared by physicians. So this would include things like a DNR or a PULSE, a physician's order for life-sustaining treatment.
Okay. Well, Chris, apart from the medical side, what are some of the important financial decision-making documents that someone could execute before they become incapacitated?
So the main one here is going to be, you'll hear it called a general durable power of attorney or a general durable financial power of attorney. This is going to be a document that grants someone the ability to manage the principal's finances. The principal is the person who enacts that power of attorney. There's a question as to whether or not that power is effective immediately. It can be effective immediately, or it can sometimes spring into action in certain circumstances.
Okay. Now, Jonathan, I'm going to turn to you. Will the existence of these documents that Chris just mentioned, will they preclude the need to have a guardian or conservator appointed?
Usually, but not always. The whole purpose of those documents is to avoid the need for a guardian or conservator. But there are situations when either the person appointed is unable or unwilling to act, or there are other things that get in the way of their ability to act under those, the authority granted in those documents. And then sometimes you will still need a guardian or conservator, but they're a real good way to avoid it in most cases, and they're very, very important documents.
Well, let's go ahead and jump. Let's just if someone has become incapacitated, Jonathan, such that they need some assistance in making medical decisions for themselves or making financial decisions, and they don't have those documents, who can make those decisions, Jonathan?
If the principal has not signed those documents, nobody has authority to make those decisions until they're appointed by a court and qualify before the clerk of courts.
So in the absence of an advanced medical directive or financial power of attorney, are there legal proceedings that can be initiated to obtain that authority so that those decisions can be made?
Yes, there are two different jobs. There's guardian, which makes healthcare decisions, and conservator, which manages the money and the assets. And they're both, you start the process by filing a petition in the circuit court where the person resided.
Okay. Well, Chris, so Jonathan just described the purpose of a guardianship proceeding. Let's just say we don't have a financial power of attorney. Tell me a little bit about what's the purpose of a conservatorship proceeding?
So when we talk about conservatorship, we're having the court appoint a person to be responsible for making decisions about finances or property. So this is going to include things like administering their debts, managing their income, managing their assets for the benefit of we call it the ward, who's the subject of the conservatorship. We can protect the respondent or the ward from scammers. Sometimes if they have a condition like dementia, we're protecting them from themselves or even unscrupulous family members.
Jonathan, as we sort of move forward now, we're going to go ahead and go to court. So let's just talk a little bit about the process that we undertake once we decide to go through that particular door. So, Jonathan, do all guardians have to be appointed? They all have to have a bond when they're appointed. Could that need for a bond pose any problem for someone being appointed a guardian?
For guardian, usually not. The court requires traditionally a $1,000 unsecured bond, which is simply the promise that you'll do your job correctly under the law as guardian. So for guardian, the bonding is rarely an issue.
Now let's talk about the conservator. Now the conservator is handling all of the money. Okay, so they apparently have to be bonded as well. Could that need for a bond pose a problem for someone who wants to be appointed conservator?
Yes, that's one place where you can really run into some roadblocks. The court requires the conservator to have a bond of 1.3 times the value of the assets of the ward, and you'll need an insurance company to issue that bond. And if you have issues with credit or judgments, that can sometimes be a barrier. It's also very hard to get a bond if you're outside of Virginia.
Okay. Chris, we've talked a little bit about bonding. Let's talk about the actual petition itself. The formal process to initiate a request for a guardian or conservator to be appointed is a formal process. So tell us a little bit about what goes into that petition that we're going to put in front of the court.
Sure. So the petition is the initial filing. It's the first document or pleading you file with the court. And there's a lot of information that is required to be in that petition. So that's going to include information about the person's condition, their mental or physical condition, where they live, information like their social security number. It's going to have to reference the proper jurisdiction, right, where we bring a lawsuit, what county or city we bring the lawsuit in. And this is based on where that person lives, or sometimes if we're talking about somebody in a hospital or nursing home, where they lived before they entered the hospital or the nursing home. In Virginia, we have to give the names and addresses of certain immediate family members. Usually at least 3 family members have to receive actual copies or notice of the petition. We have to give information about marital status, children, parents, other family members of the respondent. And then we have to talk about why that person's incapacitated, why they need a guardian or a conservator or both. And then we also get into things like, can this person speak English? Are they going to be able to attend the hearing? We have to give them notice of certain rights that may be affected by having a guardianship or conservatorship imposed, and sort of give the respondent notice of what those rights are and how they could be impacted. We reference the primary care physician. We'll also have a formal capacity evaluation done by a licensed healthcare professional, and reference whether or not there's some of the documents we've talked about, like an advanced medical directive or power of attorney. Then finally, we'll talk about who the proposed guardian is, or who the proposed conservator is, and sort of the financial information that might be relevant.
Well, there's a lot of stuff that goes into that petition. So tell me a little bit, give me some examples briefly of powers that are granted to a guardian or conservator for the respondent.
So generally, it's a pretty broad range of powers, right? So when we're talking about a guardian and conservator, obviously we're talking about healthcare decisions, authorizing healthcare. When we're talking about a conservatorship, we're talking about the power to access bank accounts, the power to sell assets, sell real estate in some circumstances. There is a limitation on how you can move people outside of Virginia. I mean, you're going to have to get permission from the court in order to do that generally. The court is not going to have power over, the court's not going to be able to grant power over property that's not in Virginia. And sometimes when we're selling real estate, there's a separate sort of hearing we may have to go to get approval before we actually sell that real estate. So it's a broad range of powers. There are restrictions though, so it's not complete.
And what are some of the, give you an example quickly, what are some examples of the powers that are, or rights that are terminated for a respondent?
Sure. So there's a number of them. I mean, it's going to include things like the right to vote, the right to have a driver's license, the right to change your marital status, the right to enter into contracts or own firearms. There's a number of issues like that.
Okay. Jonathan, let me turn to you. The person believed to be incapacitated is called the respondent. Is a medical evaluation of the respondent by a physician typically filed with the petition?
A medical evaluation is typically filed, but it doesn't have to be by a physician. There's a number of licensed professionals listed in the statute. They have to have expertise on these matters.
Okay. Now, are confidential information and documents attached to and filed with the petition?
Confidential information is, documents usually not, but the information is set forth on an addendum that is sealed in the court, so it's not available to everybody.
Okay. Well, let's talk a little bit about the guardian ad litem. Jonathan, can you explain the distinction between the guardian who we're seeking to have appointed as someone to be a guardian and the person called a guardian ad litem who shows up in this proceeding?
The guardian ad litem is appointed by the court essentially as the court's investigator to look into the facts and report to the court of whether or not the respondent needs a guardian or conservator, and if the named person is appropriate.
Now, continuing with you, Jonathan, as part of the process to obtain a guardianship or conservatorship, the court will appoint an attorney to serve as. How is a GAL selected, though?
In Alexandria, the petitioner's attorney proposes the guardian ad litem, and the court has the final decision of whether that person should be appointed or not.
All right. So, Chris, I'm going to come back to you. Now, Jonathan has talked about the importance and purpose, the role of the GAL to make a report. Who pays the fees for the guardian ad litem, Chris?
Well, there's two ways that the fee can be paid. If the respondent is indigent, then the state will pay the fee. Otherwise, if the respondent's non-indigent, then the fees will be paid from the respondent's assets.
Okay. And in order to allow the GAO to do their work, perform their duties, there certainly is a need for certain information for them to get going. Can you explain what information the GAO would want to see to get started?
So for starters, you're going to want to get contact information from family members. The GAL is going to review the pleadings and the confidential information that was filed to initiate the case. There may be medical, financial records, things like that. Okay.
Jonathan, I'm going to come back to you now, Jonathan. I know you spent a lot of time in court representing the city of Alexandria on some of their matters involving guardianship and conservatorships. After filing the petition, how long before your request will be heard by the court and acted upon?
So the respondent has to get at least 10 days notice, and that notice is usually provided by the guardian ad litem. In a normal case, they're heard on Motions Day, which is the second and fourth Wednesday at 10 a.m. by virtual hearing. And the notice has to be filed 2.5 weeks in advance of that motions day. But in some emergencies, you can get it heard sooner than that. So really the shortest time is about 15 or 20 days after the petition is filed, if it's a real emergency.
Okay. Now, who needs to appear before the court in the uncontested petitions?
The guardian ad litem has to be there by statute, and petitioner's counsel. Those are really the only ones. If the guardian and conservator have already signed the order indicating they agree to be appointed.
Okay. Now, tell me, there's a standby guardian sometimes that's being also added in the petition. Do they need to appear as well?
If they've signed the order in advance, they do not.
And how long, Chris, I'm going to come back to you now, because we're in a hearing. I know Jonathan mentioned about some of the hearings can be, I think, by Zoom or whatever the electronic means is now. How long will the hearing typically last?
So for an uncontested guardianship, it's very quick. It's usually a 5 to 10 minute hearing.
And apparently these hearings are conducted with whoever needs to be there, either assembling in the courtroom or otherwise appearing remotely. Is that true?
Yes, in Alexandria on our motions days, we do those virtually, so it's very easy.
And what happens, just because people can disagree, what happens if the petition is contested by somebody?
So in that situation, we're going to require a longer hearing. So generally in Alexandria, what parties can do is request what we call a date certain, or a specific date for the hearing. We assign it to a courtroom, and then we have a trial, sort of with all the things that you see on TV, where the judge is going to hear evidence, there's going to be testimony and things like that.
Okay. Now, Jonathan, coming back to you, we're going to get a court order. So the object when we initiate this petition is to get someone appointed, is to get a court order approving our request. Is that court order some form document that the judge simply stamps as approved?
No, it's fairly complex. The legislature has put in some very strict requirements of exact language that has to be in the order, including specifying the font and the typeface of some of the language in the order. It's a very technical thing that has to be written very carefully.
Okay. Now, would the court order that I do receive, would it give me, as conservator, the authority to go ahead and deed mom's home to somebody or make mom's medical decisions?
No, before you can act as either guardian or conservator, you have to appear in front of the clerk of courts and take an oath. And as conservator, you have to post a bond before they'll allow you to become appointed. You get a certificate of qualification from the probate clerk, and it's that document that allows you to act.
So, Chris, I'm going to come back to you. So we have the court order. Once that's signed by the judge, at that point in time, then Jonathan said you don't necessarily have the authority to do anything until you actually go down to the probate office. Talk a little bit about that.
So that is where we would go down to the probate office and we'd get the certificate of qualification, where you'd swear in, essentially, and that certificate is going to be what confers the authority on the guardian or conservator.
Okay. All right, we've reached a point now, fellows, I want to take a chance to actually draw on your experiences. So I'm going to ask each of you to give me your comments about this. As you look back over everything we've covered so far, in the city of Alexandria, the process to request the appointment of a guardian or conservator, what are some of the common problems and pitfalls in undertaking this request to be appointed? Chris, I'm going to go to you first.
So the one that I see is a lot of times people will try to DIY it. It's always good to have an attorney involved, especially when you're starting from the beginning. These are very technical proceedings. And a lot of times when people try to sort of assemble things that they've seen off the internet, it can make things difficult. So, having an attorney from the get-go is usually the best decision you can make.
And Jonathan, I'm going to come to you now with your thoughts about some of the common problems and pitfalls that you've identified from your experience, or otherwise you'd like folks to be forewarned about before they start down this road.
Well, being organized with the information is really, really important. So having the name of the treating doctor and having a medical report or knowing who to talk to for the medical report, and making sure that the lawyer gets all the information about the relatives. You want to make sure that you tell the lawyer about everybody, even that relative who perhaps is sometimes not easy to get along with or sometimes not friendly. Everybody really has to get notice. And if there's people who are excluded, that can cause problems down the road.
Okay. Well, folks, guys, we're at that point where I need to draw on some final comments. There's a lot of moving parts in this process, and this initial program really only scratches the surface of all that goes into making the process work. Every family situation has its own set of dynamics, and hopefully our viewers appreciate this is a complicated situation. It's not really something that they should undertake to do on their own. So what I'd like to ask you now, guys, if you could each, and Jonathan, we're going to stay with you, get your final thoughts, practical advice, suggestions from our discussion tonight that you want to share with our audience.
The point that Chris made, that you really should not do this yourself. This is one of those places where I've seen people try it themselves and it ends up being much more expensive, much more complicated, and can create a great deal of problems. Find an attorney who's done this type of work before to guide you.
And Jonathan, just to stay with that thought process, is it your experience that people end up spending more money in the process if they don't get a lawyer involved from the very beginning?
Absolutely. It could get, I've dealt with a number of situations that have become extremely complex and very expensive. And frankly, people have gotten in serious trouble by not doing it right the first time. And that's because they didn't understand the process. And this is absolutely a place you need to get an experienced attorney.
Chris, I'm going to come back to you to get your final thoughts, words of advice, pitfalls. If you can build on what Jonathan had to share, I would appreciate that.
Sure. I believe, like Jonathan said, organization is huge. So not just having your having your information organized, but sort of having a plan. Once we get the guardianship, what are we going to do? What are we thinking in terms of placement and how we're going to sort of care for this person? So having a plan, having all the information you need to execute it, that's a huge part of all of this.
Well, guys, Jonathan and Chris, I want to thank you guys both so much for taking the time to get us started along this process. And I want to see if I can impose upon you to come back and visit with us to take care of part 2 of this program, which we'll do another time. But again, on behalf of the Probate Nation, thank you for this great public service.
Thank you.
You're more than welcome. Thank you for having me.
Folks, if you need to get the legal authority as a guardian and conservator in order to handle the care and finances of a loved one living in the city of Alexandria, our guests have done an excellent job in part 1 of explaining what that process involves. Clearly, there are numerous steps to take to get your request to court so a judge can rule. And many of those steps deal with legal requirement in the document to be filed. So I would urge you to have an attorney assist you with this process. But the show tonight is only the beginning of this discussion. In part 2, our guests will complete your education as you head to the probate office, get officially qualified to serve, and then make your way to the train station to board the Living Probate train. There you will begin to handle ongoing duties and reporting requirements. We encourage you to tune in for part 2. This concludes our show this evening. We hope you found it informative. Just a reminder that replays of this show can be viewed on the Probate Nation website and YouTube channel. And if you want to receive monthly tips on guardianship, conservatorship, and probate matters, please sign up for the free Probate Nation newsletter. Until next time, I am Richard Ruddy, and this is the Probate Nation.